Sylvia, we'll move to Jones.
Yes, and so now we are getting into tax court in our second case, which is a gift tax case that featured two Oregon companies, related companies. And what was exciting here too was that the U.S. tax court now accepted tax-affected valuations. And the sort of more interesting question was how it would do that, because a key issue or key question has been, if the tax court ever gets to the point where it accepts tax affecting, will it overturn gross, or how will it reconcile gross and related cases with tax affecting? And so we see here that it actually manages to both. It accepts tax affecting and it keeps gross alive, at least for now. The decedent here, who died in 2014, had founded two companies. One was a working sawmill, and the other was a company that bought and held and managed timberlands. And the sawmill was organized as an S corp, and the timber company was a limited partnership. And the S corp was pretty much, or was the sole general partner in the limited partnership. It had a 10% interest, general partner interest, and it had exclusive control over managing the limited partnership. And the sawmill bought most of the LP's timber. Both companies were under the same management, and every year the LP paid the sawmill a certain amount in administrative fees. There also was a partnership agreement. So like in Kress, the recession figured into this case in that the valuation date was May 2009, and the sawmill at the time was feeling the increasing weakness in the economy, because its performance was actually dependent on housing starts. Its lumber was used to build houses. The sawmill had Class A and Class B stock. Class A was voting stock and B was non-voting. And before the valuation date, the decedent owned a majority of Class A shares, and the three daughters owned equal but less amounts of those shares. The decedent also owned most of the Class B shares, and the daughters owned equal amounts of those shares but a lot fewer. And the S Corp owned all of the general partner units in the limited partnership, and the decedent owned most of the limited partner units. And shareholders in the sawmill were subject to transfer restrictions pursuant to a buy-sell agreement, and the limited partner unit holders had no authority to participate in the company's management, but they had some input into whether or not to continue or dissolve the company, and questions regarding the appointment of a successor as general partner. As part of his estate planning, the decedent then decided to transfer blocks of stock in the S Corp, including Class A shares and Class B shares, and he made transfers of equal blocks of limited partner units to the daughters and various trusts. And he filed a form, a gift tax, a return for the tax year 2009, to which he attached valuations for the companies that were done by a valuation firm. Ultimately, the IRS determined a deficiency, and unlike in Kress, the estate here challenged the IRS's determination and petitioned the U.S. tax court for review. So this means that the posture of this case is different from Kress. The estate or taxpayer is litigating against the IRS in U.S. tax court. And the main issue, again, was fair market value of the Class A and Class B shares in the S Corp, the sawmill, and the fair market value of the gifted LP units in the timber company. The court again considered revenue ruling 5960 factors and expert testimony. The estate had an expert who had considerable expertise valuing sawmills and timber product companies, and he valued both companies under an income approach and a market approach. He used a DCF analysis and the guideline public company method. The IRS offered two experts. One valued the limited partnership, and then they brought in a second expert to just prepare a rebuttal of the opposing expert's valuation of the sawmill. So the main dispute, when you read the opinion, really is over the valuation of the limited partnership, the timber management and cultivation company. Both sides' experts valued the company on a non-controlling, non-marketable basis. The valuations were hugely different. The estate's expert said the LP was worth $21 million, and the IRS's expert found it was worth $140 million. And a key issue was whether to use an income approach, as the estate expert proposed, or the net asset value approach, as the IRS's expert did. The IRS argued that the income approach was completely inappropriate here because it said the LP was essentially a holding company whose value was completely derived from the underlying asset, the timberland. And the estate said that made no sense at all because the LP would not likely be selling the timber. For one, the sawmill had exclusive management control over the LP, and given the interconnectedness between the two businesses, which the estate throughout its argument presented as a single business enterprise, said there was no chance that a sale of the timberland was likely. The LP unit holders didn't have the power to force the sale of the timberland. And the IRS argued that a specific buyer and seller shouldn't matter under the fair market value standard. The court went back a step and said, well, companies can have both aspects of an operating company and a holding or investment company. And if that's the case, you do not limit valuation to only one method. You would consider both the earnings and the assets of the company, and then you weigh the result of each analysis depending on the weight given to the result of the asset approach depends then on the likelihood of a sale of the underlying assets. And the court in this regard and throughout the opinion sided with the estate by finding it was really not likely that the timberland would be sold, given the partnership agreement between the LP and the sawmill as a general partner, given the power of the general partner and the lack of power by LP unit holders to force a sale, and also the fact that the companies were, as the court put it, so closely aligned and interdependent. And the court said it was actually appropriate, given the setup, to consider the company's relationship. Any hypothetical buyer and seller of an LP interest would consider the power dynamic between the companies and the transfer restrictions on limited partners that were applicable under the partnership agreement. So the estate won on that issue. The other big issue was whether in performing a DCF analysis, the estate's expert appropriately tax affected, both when he valued the LP, the pass-through entity, and the S-Corp. He treated the company as a taxable C-Corp at an individual, not corporate tax rate. Importantly, though, and unlike in Kress, he also accounted for a dividend tax avoided by calculating the benefit to partners in prior years and looking at an empirical study on S-Corp acquisitions. The IRS, as in the past, brought out the usual arguments against tax affecting by saying that there was no way the company would change to a C Corp. The company was not liable for taxes on an entity level, and also accepting tax affecting, the IRS said, would violate the premise of the fair market value standard unless you could show that unrelated parties dealing at arm's length would tax affect earnings. So the IRS, as in the past, suggested using a zero tax rate. And the court dismissed all of these arguments. It said that, in effect, both sides know that a hypothetical buyer and a seller would consider the company's corporate form. The question was, how do you do that? And the court said that the IRS's experts didn't really argue against tax affecting. That argument was really made by the lawyers. The court said that gross and then also subsequent decisions to Stina and Gallagher were cited by the IRS could be all of them, in all of them the court rejected tax affecting. But the court in this case said all of these cases can be distinguished on the facts from the current case. And in Gross specifically, the tax court faced a proposed valuation using a 40% tax rate with no consideration of savings to the owner because of the S-Corp status. And so given that situation, the Gross court found that based on the record, and this is really an important qualification, a 0% corporate tax rate as suggested by the IRS may be better reflected the tax savings. So this, it must be said, is really the interpretation of what happened in Gross by the court ruling on the current case. The court also, as I said, found that it could differentiate the facts into Stina and Gallagher. And so it ultimately ended up saying on the record before it, it found that the estate's expert much more accurately accounted for the tax consequences related to the pass-through entity and the S-Corp status. It said that the experts, the estate experts' tax affecting may not be exact, but it is more complete and more convincing than the IRS's proposed zero tax rate. So summing up, from the court's opinion, I think what one can take away is that, one, every case is being assessed on the facts of the case. And therefore, it's critical for the parties to build a record, including through expert testimony. And two is that in accepting tax affecting so readily, the tax court actually suggests that the IRS's prior position, just arguing for a 0% tax rate in all cases based on growth, is no longer a successful strategy. The slides actually include a discussion of other valuation issues that the court decided, but I want to make sure, Jim, you have enough time to make your points on this case.
Thank you. Great job, Sylvia. And I hope I didn't confuse anybody with my comments on the last case as to the difference in the court venues. But Sylvia is absolutely right. This is a tax court case. My bottom line on this is that my take is that if properly presented by the expert, the tax court will not restrict tax affecting again. I think they're going to look at the facts of the case. I frankly think that their, quote, excuse in their opinion for defending why they came up with the answer they did in the Gross case, which I'll say again was a 67% premium, and there's just no way that you can ever justify that kind of a premium. I think they realized that over the years. So this case gave them an opportunity to assess this whole issue again, especially since the IRS came in this case, with zero tax effect, and they pretty much pushed that aside. I think also that if you look for cases where the facts take place after the implementation of the new tax act, the TCJA, the entire issue of PTE tax effecting and PTE premium will be a thing of the past, because there clearly, in most cases, is no benefit to an S corp. When you look at the rate structures in the new tax act, there's no longer any possibility for an argument saying that that there's a tax benefit flow through to a pass-through entity. So I think that will be the case going forward. And again, you need to distinguish the facts in your case. And so it's like every other thing that you do well or don't do well, you've got to present a valid argument in order to be successful on this issue. The issue of both the net asset approach and the non-operating asset issue, again, is front and center in this case, as it was in the Kress case. Again, in this case, you've got timberland, and timberland, I have done a couple of valuations on companies that owned and operated timberland operations, lumber operations, and owned the timberland. I've also done a number of cases on limestone quarries. Indiana has some of the best limestone in the world, and it's highly sought after. But the problem with both the timber and the limestone is that it depends on what the market is doing at that point in time. In both in the Jones case, as in the Kress case, the time frame overlapped the Great Recession. Now, in the Jones case, their company's sales of timber was to build houses. Well, we all know that during the 2008-2009 recession, the housing market went flat or below flat pretty much all over the country. So there was a lesser demand for the product. So when you take into account, well, look, I've got standing timber here that might last, with proper management could last forever, but you could say maybe has 100 years worth of timber based on certain sales levels or whatever, that's only good in the value of the business as it relates to how much of that lumber they can sell in a given year. So you go back to saying the income approach makes the most sense if you're not going to sell the timberland, which in Jones' case they said they were not, and if you're going to continue to operate a timber lumber operation to sell lumber for building houses. So the court, I think, very astutely and very appropriately looked at that issue and said, well, look, we're not selling off this timber, and we're talking about minority shareholders here. And so the minority shareholder value is going to be impacted by the inability to access that timber or force the sale of it as a unit. And even if you were going to sell that timberland off as a unit at that point in time, you would have to question perhaps some of the value of the timberland because there would be a discount for what was happening in the economy at that point in time. So I think both these cases, as much as the tax affecting has made the news and the headlines, and certainly that's one of the bigger issues in both of these cases, this issue of what do you do with non-operating or net assets in a valuation is as important. And you can see in both of these cases that the assets are not really clearly non-operating. They provide the raw material for the operations of the business, but it still gives you a good clue as what do you do with non-operating assets in a minority shareholder. The last point I want to make is that valuing the two entities together as a single entity. I get this question frequently also, and I think the answer is exactly what the expert for the taxpayer and the court decision came up with, which is when these entities are so interdependent, as they are in this case, the actual legal structure of the companies had more to do, most likely, with the estate issues and estate planning issues than it had to do with the actual legal operations of the company. And so it was appropriate, the court decided, to put those two companies together and value them as one entity. That also kind of clarifies that point of what do you do with the timberland as a separate asset value. So, Sylvia, those are my thoughts on that, and you can either add a couple or we'll move on to the next case.
Great. No, I think that sums it up well.